Hello and good morning to everybody today. My name is Francis Mortin. Welcome to our first seminar in the Post Liability and the Employment Tribunal series. I'm joined today by my colleague Anthony Johnston. Anthony, would you like to introduce yourself to everyone for the seminar?
Yeah, good morning, everybody. As Frank said, my name is Anthony Johnston. I'm a barrister of a little over 30 years call, and like Frank, I'm an employment specialist. I've practiced in employment law throughout my career and have specialised solely in employment law for about the last 10 years. Perhaps pertinently, given some of the things that we're going to discuss, prior to specialising solely in employment law for about 20 years, I also practiced in the field of personal injury.
Thank you, Anthony. And as for myself, I'm 5 years call. I did previously, though, work in a large commercial firm, and I was a solicitor advocate for 2.5 years before that, and trained as a solicitor as well. Always as an employment specialist, save for my training contract. And I've also had a similar experience, not to the obviously the breadths of Anthony's level of call, but have had experience dealing with remedy issues inside the Employment Tribunal, both working as a solicitor and also as counsel and acting for both claimants and respondents at final hearings and remedy hearings. The first seminar that we have in our series is effectively titled What's to Blame? And what we're going to be looking at is issues of causation, divisibility and apportionment insofar as that narrow segment applies to particularly discrimination claims. Moving then towards our agenda, so you can see what we're going to be doing today in each phase. We've got, at the beginning, I'm going to take you through an executive summary on the issues of remedy, and that includes when you should start thinking about it, some practical tips for what helps when thinking about the issue of remedy at play, when considered in tandem with liability. Moving on, Anthony's going to take you through a whistle-stop tour of causation. Now, obviously, a very large topic, but what we're going to deal with is the main areas in which you may find yourself dealing with issues of causation, particularly in relation to remedy. The third aspect, as the title of the seminar goes, is going to be dealing with divisibility. And I'm going to be taking you through divisibility of loss. Now, that primarily applies to injury to feelings, psychiatric injury awards, and I'm going to be taking you through what you can do if you're going to try and argue a divisibility sort of argument. And Anthony's going to helpfully provide us with some additional assistance on personal injury awards, particularly within that sphere. And Anthony's then going to take us through some things on apportionment. We're going to close by dealing with some typical scenarios, typical questions that you may come across. And if we have time at the end, we'll take some questions from the group. So you can use the chat function, the Q&A function, and we'll try and come to your question at the end if we can. Briefly going through it, as many of you are lawyers, no doubt, you're all used to abbreviations. I've just quickly set these out for you on this slide. Nothing really controversial, I would imagine, but simply makes life easier for us all. If we now get into it then, the first thing to deal with remedy is obviously once you're at the stage of remedy, the issue of liability has been determined. You have either won your case, so great for you and for your client, or you've lost your case because the nature of our system is adversarial. But that's not by any means the end of the issue, unless you have a straightforward wages claim, for example, where you're arguing over a set amount of money. Most of the time, the issue of compensation is still something that needs to be determined. And with that, I think that this slide, down but not out, that really does set the scene for what this talk is all about. And dealing with the issue of remedy, that's something that both sides have to argue, and both sides still have a really good crack at it, to put it bluntly. Now, the issue of when to start considering remedy, it may sound obvious, but it's important to do so at the very outset of a case. For claimants, the claimant is probably going to want to know, well, what's my claim worth? And we see it, Anthony and I see it, and I'm sure you do, particularly if you're working primarily for respondents. You'll see schedules of loss in the hundreds of thousands, when in reality the claim is worth maybe 30,000. And the same goes for the respondent, though. The respondent client is going to know, well, if I'm liable for this, what is the eventual outcome if I lose? And that can then shape the way in which you approach the claim, as to whether or not an early settlement is advisable, whether or not there's particular points on remedy that you want to take at the outset. Particular points may be a Polke style argument, also known as a Chagger style argument in discrimination claims, i.e., but for the act, would the person have been dismissed in any event? And really, that takes us into what the third point on this slide suggests, which is the issues of causation, divisibility, and apportionment all go to the final figure, to what a tribunal may end up awarding a party. Now, one of the things is you need to look at the overriding picture there, and from the documentation that you get from the outset from your client, you should be able to start identifying whether or not there are issues of causation, whether there are potential pitfalls as to divisibility, and also if there are multiple respondents, for example, whether there will genuinely be an issue of apportionment. And we're going to cover those matters, but I'm now going to hand over to Anthony to deal with the issue of causation. But I think there's another point here, Anthony, isn't there, about when you start considering it, whether one of the things that practically stands out to me is whether or not, well, do you want a split liability and remedy hearing?
Absolutely. And I think particularly in a case where there are going to be, or detailed consideration of remedy up front is rather more problematic. So, for example, cases where there's a significant personal injury alleged and there are potential issues in relation to the causation and the attribution of that, cases where there's substantial pension loss, particularly defined benefit scheme cases. I think those are typically candidates where you ought to be asking for a split liability and remedy hearing up front. But even then, as you've been saying, that doesn't mean that you shouldn't be thinking about remedy, because there's an obvious difficulty in simply kicking the can of remedy down the road as something to be thought about once liability has been determined, which is that by the time you come to consider it, you're already faced with adverse liability findings, and necessarily the parameters for settlement will have narrowed. And you ought to be thinking at an early stage about what different aspects of the claim are worth, and significantly, as we're about to come on to, the causation in respect to those elements and any causation issues that there may be in respect of those different elements.
Well, before we move on to causation, I suppose a clear point that arises just from what you've said, Anthony, is the prospective medical report and whether one's necessary, whether, and assume most of the time you would, and the guidance says you should get a joint instruction on it. But that's another matter that really arises from what you've just said, isn't it? Do you get a medical report, and if so, at what stage?
Absolutely. That I think, and we'll come on to it in due course, it is slightly more problematic, because one of the things that you're going to want any medical expert to address is what personal injury is attributable to the harm that the tribunal has actually found, and therefore there are difficulties, I think, and as I say, I'll come on to it in due course, in obtaining a medical report up front, because that will necessarily deal with the totality of the picture and won't be quite as nuanced as you might want it to be, certainly as a respondent, in terms of dealing with the tribunal's findings on liability.
Absolutely. But I think it's, if we now go on to causation, Anthony, I believe you were going to cover that.
Yes, certainly. At the risk of stating the obvious, causation is obviously the cornerstone of awards of compensation, awards of damages. Stated simply, if you cannot establish causation in respect of a particular loss, you can't recover it. And the slide that we have in front of you sets out the way in which the issue of causation is approached in respect of some of the key jurisdictions we have to deal with as employment lawyers. So firstly, on the left, unfair dismissal, which is the one with which I think everybody will be familiar. Section 123 of the Employment Rights Act, which is the section of the ERA dealing with the compensatory award, section 123(1 provides that loss suffered by the employee must be attributable to action taken by the employer. Now, one of the key areas with regard to causation in an unfair dismissal case is the effect of new employment upon the question of whether or not loss can be attributed to the action taken by the employer, that is to say, the dismissal. We'll all be familiar with cases where an employee has obtained either equally or more highly remunerated employment following their dismissal. They're still in that employment at the date of the tribunal hearing. In those circumstances, no difficulty at all. The new employment acts as a cut-off point. But what we're going to look at now is some slightly more nuanced situations. We've seen in the EAT case of Courtaulds Northern Spinning Limited and Musa, which is a 1984 case, that an employer can successfully argue that an employee's losses are no longer attributable to the employer's action, even where the employee has subsequently become unemployed again. That case concerned an employee who worked in new employment for a period of 18 months, but was then dismissed again before the tribunal hearing of the original claim. They tried, perhaps slightly cheekily, to claim ongoing loss after the loss of the second employment. The EAT held, perhaps unsurprisingly, that the original employer's liability ceased when the employee entered the new employment. In similar vein, in the case of maybe Plantar and Richards, which is a Court of Appeal authority, an employee got a new job for which he was overqualified at a lower rate of pay. So, familiar scenario to employment lawyers where there's an ongoing loss beyond the date upon which alternative employment was obtained, represented by the shortfall between the old earnings and the new earnings. He was subsequently dismissed from that new job a few months later as a result of a clash of personalities and a failure on his part to comply with company rules. He sought to recover his full losses after the date that he lost the new employment. And the Court of Appeal said, no, he couldn't do that. The new employment could have been permanent, and it had come to an end for reasons which were entirely unrelated to any action which had been taken by the original employer. The chain of causation was therefore broken, and any future loss was restricted to the difference between the employee's original salary and the salary which he would have continued to earn with the second employer, but for the second dismissal, so effectively projecting forward the shortfall. However, it's right to observe that it's not invariably the case that new employment will break the chain of causation. A tribunal can, in appropriate circumstances, conclude that the employee's loss following the termination of new employment is still attributable to the first dismissal. For example, where the period of new employment is short. An illustration of that is the case of Dundee Plant Co Limited and Riddler, where the employee found a new job but gave it up after 3 months, as the tribunal found reasonably, when that new employment proved unsuitable. The EAT in those circumstances upheld the first instance tribunal's finding that the original employer's liability didn't come to an end when the employee found a new job. In similar vein, in the case of Witham Weld and Headley, an employee gained new employment immediately after her dismissal, but it proved to be unsuitable, and she left after 4 weeks. Again, the EAT in that case upheld the tribunal's decision to award ongoing loss, stating a reasonable but unsuccessful attempt to mitigate does not cut the chain between the wrongdoing and loss which on ordinary principles of causation flowed from it. The Court of Appeal came to a similar conclusion in the case of Dench Flynn and Partners, and in doing so overturned an ET's decision that the claimant wasn't entitled to compensation where she'd taken up new employment even though the new job had then been terminated by the new employer after only 2 months. The Court of Appeal took the view that there was no hard and fast rule as to whether permanent alternative employment broke the chain of causation for loss. The tribunal's only duty was to award what was just and equitable in all the circumstances of the case. Onto the middle. Thanks, Frank. Discrimination. In terms of financial remedy, Section 124(2)(b) of the Equality Act provides the tribunal may order the respondent to pay compensation to the complainant. The amount of compensation to be awarded corresponds to the amount which could be awarded by the county court under Section 119 of the Equality Act, which expressly provides that an award of damages may include compensation for injured feelings, irrespective of where there's any other compensation. So that's where that entitlement comes from. As with any claim in tort, the measure of loss in discrimination cases is, at the risk of stating the obvious, tortious. As far as possible, the claimant must be put back in the position that they would have been in had the discrimination not taken place. And you have on the screen a quote from Justice Mortin in the case of the Ministry of Defence in Cannock. The correct measure of damage is based on the principle that, as best as money can do, the claimant must be put into the position she would have been in, but for the unlawful conduct of the employer. The third type of claim that we have on the screen is detriment claims. As you will no doubt be aware, there are a number of different bases for detriment claims under the Employment Rights Act. Perhaps the one you will most commonly encounter is whistleblowing detriment, but there's been an increase in recent years in Section 44 health and safety detriment claims, primarily as a result of the effects of the COVID pandemic. You'll also commonly see detriment claims brought under the MAPLE regulations alongside pregnancy and maternity discrimination complaints. The starting point with regard to detriment complaints is, as set out on the screen, Section 49(2) of the Employment Rights Act, which provides that the tribunal shall have regard to any loss which is attributable to the act or the failure to act which infringed the complainant's right. Now, in the case of Robertson Wilson Solicitors LLP and others, the Court of Appeal considered what's meant by the word attributable in that context, and it found that the word attributable imported the common law concept of but-for causation. That is to say, the relevant loss would not have occurred but for the unlawful act. However, having said that, the fundamental basis for the Employment Tribunal determining the amount of compensation in a detriment claim is that the compensation should be such compensation as is just and equitable in all the circumstances. Similarly to the position in relation to unfair dismissal cases, when ascertaining the loss, the tribunal specifically directed to apply the same rule concerning the duty of a person to mitigate his or her loss as applies to damages which would be recoverable under the common law. On the slide that we're now looking at, we have a number of key takeaways as far as causation is concerned. The first is, as set out in the first bullet point, in most cases that come before the Employment Tribunal, the test for causation is in fact wider than the common law equivalent, the but-for test that I mentioned a moment ago. Now, an illustration of that is the position with regard to loss in discrimination cases, which is perhaps of particular significance with regard to awards for personal injury, which we're going to come on to in due course. Those of you who have practiced in personal injury will be aware, those who haven't will probably be aware, there's a dim and distant memory from either university or law school, that in order for damages to be recoverable, for example, in negligence, the type of harm must be reasonably foreseeable. Importantly, there is no such requirement in a discrimination case. The authority for that is Esser and Lang, which you have on the slide. In order to be entitled to compensation for loss in an unlawful discrimination case, it isn't necessary for a claimant to show that it was reasonably foreseeable that they would suffer that particular type of loss, for example, personal injury, as a result of the alleged discrimination. In Esser itself, the claimant had suffered depression following an incident of racial abuse. The tribunal at first instance had held that that wasn't reasonably foreseeable, and therefore the claimant couldn't recover damages in respect of it. A majority of the Court of Appeal said, no, it isn't necessary for loss to be reasonably foreseeable in a discrimination case. Rather, the entitlement is to be compensated for the loss which arises naturally and directly from the wrong. It's sufficient if the claimant shows that the particular type of loss claimed, in that case personal injury, as a matter of fact, resulted from the act of discrimination. And the measure of compensation recoverable upon a discrimination complaint will therefore be all of the loss that flows from, that's to say, is legally caused by the act of discrimination. And it's important to bear in mind when the act of discrimination is dismissal, the loss isn't restricted by the financial limitation on the compensatory award for unfair dismissal, the statutory cap which is applied by section 124 of the Employment Rights Act, or indeed by reference to any deduction made from the unfair dismissal award on the ground that the claimant contributed to their own dismissal, section 123(6) of the Employment Rights Act. Second bullet point, there can be no double recovery. As I just mentioned, tribunals that are faced with an unfair dismissal that's also an act of unlawful discrimination should award compensation for loss on the principles which apply to discrimination cases. You can't simultaneously recover a compensatory award for unfair dismissal in respect to the same loss. Similar considerations apply, for example, where you're dealing with a gross misconduct dismissal and there is a claim for wrongful dismissal, that's to say a claim for notice pay and a claim for unfair dismissal. You can't recover a compensatory award in respect to the same period as is covered by the notice pay award. The third bullet point on the screen, it's important to recognise that there are two separate issues. Firstly, of remoteness of damage, and that is concerned with whether legal causation in respect of a particular loss can be established. And secondly, mitigation. That they are separate and distinct issues. Mitigation falls outside the ambit of this seminar. It would take up a seminar in its own right. However, as we flagged up on the slide, one important matter that you have to bear in mind when it comes to mitigation is that the burden of proof is upon the wrongdoer. So it's not for the claimant to prove that they acted reasonably in mitigation of their loss. It's for the respondent to prove that they didn't. And in terms of the distinction between remoteness and mitigation, the case of Wilson and Glenrose Fish Merchants Limited and another involved an employee who had poor prospects of obtaining new employment and therefore chose to claim sickness benefits for a period of 2 years before they then became unemployed. The EAT in those circumstances held that the first instance tribunal had been wrong to award no future loss on the ground that causation between the employee's dismissal and his current employment had been broken by him claiming sickness benefit. Rather, what the tribunal ought first to have done was consider the issue of mitigation and consider whether claiming sickness benefit for that period was, in all the circumstances, a reasonable action in mitigation of loss. The final bullet point on this slide, there is an overarching principle in the assessment of compensation in respect of Employment Rights Act claims, so unfair dismissal claims and detriment claims, that the tribunal will assess compensation on the basis of what is just and equitable in all the circumstances.
And I think that you've just, before when we were discussing the previous slide and you were discussing detriments, Anthony, you also identified the issue of just and equitable in the circumstances, that being the overarching matter when the Court of Appeal was looking at the word attributable and what happens there. But what would you say is a practical example of a tribunal taking into account something that's just and equitable in the circumstances, something that they would take into account?
Yeah, I think probably the most classic example of the just and equitable principle is the case of Davis and Atkins, with which people may well be familiar. In that case, the claimant was found to have been unfairly dismissed by the tribunal. However, after he had been dismissed, the employer had discovered incontrovertible evidence that the employee had committed certain acts of misconduct during the course of his employment, in respect of which they could and would have dismissed him. To place that in context, The respondent was an abattoir, and amongst other things, Mr. Atkins was discovered to have been dealing in live animals, effectively diverting them away from the abattoir, which was to the obvious detriment of his employer. The misconduct plainly didn't cause or contribute to Mr. Atkins's dismissal, so there couldn't be a reduction made under section 123(6) or its equivalent back then, as the respondent was completely unaware of it at the time. However, the tribunal determined that in those circumstances, it would be unjust for the claimant to receive any compensation whatsoever, as he could and would have been fairly dismissed if the employer had known what he'd actually been up to. That's the case which went all the way to the House of Lords. They upheld the tribunal's decision at first instance. Another example, I suppose, is in relation to whistleblowing cases. You have what is now enshrined in Section 49(6)A of the Employment Rights Act, which gives the tribunal the power to reduce an award of compensation by up to 25% if it appears that a disclosure, which it has found to be both a protected disclosure and that the claimant has been subjected to detriment as a result of, wasn't in fact originally made in good faith by the claimant.
No, thank you. I think that both of those points, really, they go back to our overarching summary at the beginning of this seminar, don't they? To say, well, just because liability is established, that does not mean that that's the end of the battle. Because as you've pointed out there in Davis and Atkins, he was awarded nothing in the end. So despite the finding of liability, at the end of the day, the respondent didn't have to pay him anything. So I think that really sets the tone for the rest of the seminar as well. If we move on to the next topic, so now that we've dealt with roughly dealing with causation in a broad brush approach, we're now looking at the issue of divisibility. Now, divisibility is a concept where effectively, and it may apply in pecuniary loss, in respect of pecuniary losses, but it's more typically seen in connection with injury to feelings awards with discrimination cases, or personal injury awards for psychiatric damage, which the tribunal also has jurisdiction to determine. And what divisibility does as a concept is it effectively says, well, because you have to go back to what the tribunal can award in respect of these matters is something in respect of, say, a discrimination claim that's been proven, discrimination, harassment, victimization, and so on. But the tribunal can only award some compensation in those circumstances for the specific act that is proven. It cannot award compensation for, say, injury to feelings for a matter that's not been proven to be an act of discrimination. Now, the typical example in here would be to say the claimant has something happen to them 3 years ago, and that caused severe hurt and upset to them. But then in between that period up to present day, the claimant has fully recovered. There's then a minor act of discrimination or harassment, and I use the term minor insofar as I'm saying it has a minor impact upon the claimant. And then the claimant is successful in that action for that narrow complaint, and then seeks to rely upon the previous hurt and upset caused by this act that happened 3 years ago. Now, in those circumstances, the respondent could seek to argue, well, the hurt and upset that's been caused here is not in any way linked to what happened 3 years ago. Now, Anthony may talk to you shortly about what's called the eggshell skull principle, but for the moment, I just want to identify that that's the sort of scenario that we're looking at in a very blatant example. But quite often these cases are a lot more complex, and they often are intermingled because there's usually some action by the respondent which may have caused some harm in the past, but the claimant is seeking to rely upon in the future. Or it may be one long chain of continuous events. Now, that's a matter for you to determine, and it's something that particularly I know respondent clients who get all of the documentation from their client generally at the outset of a matter, or most of it at least, when you go through those documents, that's something to be aware of and to be mindful. Well, does the individual that's bringing a claim for, say, discrimination, do they have previous existing conditions? Does that explain why they've particularly reacted badly to something that's happened at work, or why they're alleging that this is discrimination or victimization or one of the many other heads of discrimination that there are? Ultimately, the important thing to remember here is that, and this is set out in the second point on the slide, is that the respondent is only liable to the extent that the conduct in question caused the injury. Now, that's the point that I've already been making. But the principle, and this is the crucial aspect, the principle is only applicable where the extent of the harm attributable to the discrimination can be untangled from another non-discriminatory reason. And that comes from the Court of Appeal's decision in Base Systems and Conchac. There's another decision of the EAT from 2010, which is worth reading as well, which is called Thane and London School of Economics. But effectively, Base Systems and Conchac, that's the most up-to-date authority to look at. And the correct approach to apportionment of a psychiatric injury in the context of divisibility, let me identify. It was dealt with in BAE Systems, and the particular paragraphs that I'd invite you to read, and having discussed it with Anthony, we consider also paragraph 72 to be particularly helpful in this regard, is paragraphs 71 and 72, which you can see paragraph 71 on the slide here. And the important segments have been emboldened and underlined. And ultimately, the best way of putting it is near the bottom of the slide. You can see that what the Court of Appeal determined is the question is whether the tribunal can identify, however broadly. So this can be a broad assessment. It need not be specifically particular or meticulous, but what it needs to identify is whether a particular part of the suffering, which is due to the wrong, i.e. the suffering caused by the act of discrimination that's proven, not whether it can assess the degree to which the wrong caused the harm. So there's a clear difference in terms of causation and harm in this case. So it's not about determining, well, what caused the matter. It's determining about, well, can we separate the harm from Act A compared to Act B, which is the act of discrimination. That's possibly the best way of putting it. So what you have to do is you have to genuinely be able to untangle the harmful impact on someone from one act as opposed to another. Example, as I've given previously, if the discriminatory conduct caused some minor hurt or upset, but the major hurt and upset was actually due to something that cannot be laid at the employer's door, then that's something that may bring a divisibility argument into effect. Now, dealing with that and dealing with divisibility is quite often argued as well. Certainly in my experience, having only recently done a remedy hearing in which this was one of the major issues, in which I was for the claimant, but part of that is that the claimant was seeking a personal injury award for psychiatric damage caused by acts of victimization. Now, with that, I'm going to hand over to Anthony, given his previous personal injury experience. So, Anthony, would you talk us through personal injury awards and a little bit of information in relation to this slide?
Certainly. An employment tribunal can award compensation for psychiatric injury which arises from a discriminatory act. That's now trite law, but if you require an authority for that, it's Sheriff and Klein Tuggs Lowestoft Limited. As we've already seen, though, from the case of Esser and Lang, in a discrimination case, personal injury doesn't actually need to be a reasonably foreseeable consequence of the discrimination in order for damages in respect of it to be recoverable. However, in terms of assessing the value of any personal injury claim, the Employment Tribunal must approach the assessment of damages for psychiatric injury on the same basis as a common law court in an ordinary action for personal injuries. That's the case of HM Prison Service and Salmon. Now, the starting point, as we were discussing earlier, is that ordinarily, and certainly in a case of any complexity, you will want to need a medical report dealing with issues of causation and prognosis, and potentially, as we'll come on to in due course, attribution. However, an expert report is not an absolute requirement in order for an employment tribunal to make an award of damages for psychiatric injury. And that is so even if the psychiatric injury alleged is comparatively serious. The authority for that proposition is the decision of Mrs. Justice Simler in the EAT in Hampshire County Council and Wyatt. It's perhaps relevant that the appellant in that case was a litigant in person, but Mrs. Justice Simler expressly rejected an argument in that case that an award of damages for personal injury couldn't be made in the absence of expert medical evidence in every case except for those which were incontrovertibly of low value. She did, though, recognise within her judgment that in cases where arguments arose as to the divisibility of harm, it would be in the respondent's interest as much as the claimant's interests to obtain expert medical evidence, and also suggested that where possible, such reports should be obtained, as they are within the field of personal injury litigation, where possible, on the basis of a joint instruction. In terms of assessing awards for psychiatric injury, the tribunal must have regard to the Judicial College guidelines, which will be extremely familiar to any of you who have ever practiced in the field of personal injury. It is a thin book running to just over 100 pages. It's presently in its 17th edition. And if you don't immediately have access to one, it costs around 20 quid on Amazon and is a useful investment. It sets out the bands of general damages for pain, suffering, and loss of amenity for various different types of injury. Perhaps the most relevant part of the guidelines for employment lawyers is Chapter 4A, which deals with general psychiatric damage, and which sets out 4 brackets for awards of general damages, covering in broad terms, you've got the precise figures there, but in broad terms, a range from just under £2,000 up to just over £140,000. The Judicial College guidelines indicate that when you're valuing general damages for psychiatric injuries, there are essentially 4 key factors. They are, firstly, the injured person's ability to cope with life, education, and work. Obviously, in the employment context, it's probably only going to be life and work which are going to be particularly relevant. Secondly, the effect on the injured person's relationships with family, friends, and those with whom they come into contact. Thirdly, the extent to which treatment either has been or would be successful. And fourthly, the question of future vulnerability. Now, against that background, there are the 4 brackets, which are described as severe, moderately severe, moderate, less severe. The top bracket is reserved for cases where there are marked problems with all 4 of the key factors, and the prognosis for any future improvement is very poor. It is frankly unlikely that you will come across very many employment cases that will fall into that particular category. The next bracket, which covers awards from, in round terms, about £25,000 to about £65,000, is where there are significant problems with the 4 key factors, but there's a much more optimistic prognosis. The guidelines indicate that most cases that fall within that bracket will fall somewhere near the middle of it. So that's to say around £40,000 to £45,000. And that's likely to be the appropriate bracket for cases of work-related stress resulting in a permanent or long-standing disability, preventing a return to comparable employment, subject only to arguments in relation to pre-existing vulnerability, which we'll come on to in due course. As far as the next bracket is concerned, moderate in round terms, awards from £7,000 up to about £25,000. The sort of problems associated with the four key factors will all have been present, but there will have been marked improvement by the date of the final hearing, and the prognosis will be good. And that's the appropriate bracket for cases of work-related stress and related psychiatric conditions where the symptoms aren't particularly prolonged. The less severe bracket, which covers awards from £2,000 to £7,000, the direction is for the level of award to take into consideration the length of the period of disability and the extent to which daily activities and sleep are affected. But frankly, if you have a personal injury case which is falling within that bottom bracket, it is likely that the tribunal will take the view that it isn't appropriate to award a separate award in respect of personal injury, and it can properly be wound up with the injury to feelings award. The key matter to take into account when you are considering personal injury is that there is a difference between, on the one hand, proof of damage, and on the other hand, the assessment of damage. In terms of proving damage, a claimant must prove on the balance of probabilities that the respondent's act or omission caused the harm in respect of which he is claimed. However, when it comes to the assessment of damages, a tribunal can go further and it can inquire into what would have happened, either in the past or in the future, if the employer hadn't caused the harm to the claimant. Now, that might require the tribunal to assess the chances that one or more particular events would or wouldn't have occurred, and it calls for a different approach. And that's of particular relevance in cases where the claimant has either a pre-existing condition or a pre-existing vulnerability. And in that regard, there are two concepts which are very familiar to personal injury practitioners, which are called exacerbation and acceleration. And I'll explain the way in which those concepts impact upon the assessment of personal injury awards in just a few minutes. However, before we get on to that, there's some useful guidance provided to tribunals in relation to the approach to be taken to the matters we've just been talking about, which is contained within the Remedies Handbook. The first of those goes back to the point that Frank was talking about in relation to divisibility. That is to say, where there is more than one cause of a psychiatric injury or injury to feelings, the respondent will only be liable to the extent that the discriminatory conduct caused the injury in question. However, as Frank's already explained, that principle is only applicable where the extent of harm attributable to the discrimination can properly be untangled from another non-discriminatory cause. Otherwise, the respondent's liable for the whole of the injury. The correct approach to the apportionment of a psychiatric injury is the one set out at paragraph 71 of BAA systems, which Frank talked you through earlier. As far as the second bullet point is concerned, important to bear in mind if you are acting for respondents, the burden is on the employer to raise the issue of apportionment. If it isn't raised, then the default position will be that there is no need to attempt to untangle the cause of the harm, and the respondent will be liable for the whole of the injury. So if it's clear that the issue of apportionment is going to arise, it's a matter that ought to be expressly pleaded by a respondent. If it only comes to light at a later stage, for example, when the claimant provides their schedule of loss, it ought to be flagged up as a potential issue as soon as it becomes obvious that it is going to be an issue.
Absolutely, and I think that that's a matter that should really be recorded in a list of issues in relation to remedy, if that's going to be something that the tribunal is then going to have to determine. Wouldn't you agree, Anthony?
Yeah, I do agree. Yeah.
I'm going to take you through the next couple of points that are in some of the points that we've taken from the handbook's guidance, and really this goes back to the points about divisibility still, insofar as where the tribunal can, it should try and identify a rational basis on which harm suffered can be apportioned between a part caused by the employer's wrong and a part that's not so caused. Now, I've already spoken about that somewhat, but it's important that to remind oneself of what the handbook guidance says, because the employment tribunals are told that they should apply this guidance. And what the tribunal can do is it should look at whether it can do so even in broad terms as to separating the harm. And point 4 really goes on to build on that, which is that where a rational basis can be found, the tribunal should apportion accordingly, even if the basis for doing so is rough and ready. And I can give an example of a hearing that I've recently been involved in which there was a split liability and remedy hearing. And eventually, when we came back for remedy hearing, what the parties agreed upon is, because divisibility issues were then raised by the respondent, at that juncture, it became apparent to all involved that perhaps a joint expert instruction was required. And in that case, questions were prepared for an expert, a joint instruction was issued. The expert unfortunately didn't deal with the question of divisibility. In that case, there was a claimant that previously there was an ongoing set of circumstances in which a claimant was off work for a long period of time. The major hurt and upset by the respondent's case was the major hurt and upset was caused by a grievance that was lodged by other people against the claimant. And then subsequently, she went on a long period of sickness absence due to stress, anxiety, and so on. She then was about to return, and at that point, there were several acts of victimization that culminated in her dismissal. So what the respondent argued, well, actually, all the harm's been caused prior to the acts of victimization that happened, and her unfair dismissal, and so on. Whereas what the claimant argued, and what we successfully argued, was that the harm was indivisible. And what the tribunal came back on was to say, well, actually, the parties realized that the expert hadn't dealt with this on the first occasion, so further questions were put to the expert, and the expert still couldn't divide the harm. So although there was good arguments for what's the causative contribution here, the expert couldn't untangle the harm, and the tribunal leaned on that in their own judgment to find, well, they couldn't untangle that harm either. So that really emphasizes that it's about untangling the harm, not the causative issue there. So, Anthony, I'll hand over to you for the next part of the guidance, because it neatly goes on to the PI subjects that you were discussing previously.
It does. I mean, the fifth and sixth bullet points are both really aspects of the concepts of exacerbation and acceleration that I was talking about a few moments ago, and I'll talk about it some more in due course. The first is that any assessment has to consider any pre-existing disorder or vulnerability that the employee had, and account for the chance that the claimant would have succumbed to the harm which is alleged to have been caused by the respondent in any event, either at or about the same point in time or at some defined point in the future. And finally, in the case of psychiatric injury, careful evidence needs to be obtained from experts, particularly in relation to that last point, the likelihood that the claimant would have suffered from the harm that is alleged to be the responsibility of the respondent in any event. I think we're now going to move on to apportionment. Apportionment has a number, probably three different meanings. We're covering two of those today. The two meanings which are relevant for present purposes are, firstly, the apportionment of damage as between discriminatory and non-discriminatory causes. That's the situation that Frank has already spoken about, and we've already considered, where harm suffered by the claimant is partially caused by extraneous factors other than the discrimination for which the respondent or respondents have been found liable, and it goes back to issues of causation and divisibility. The second, and the one which I'm going to talk about now, is apportionment as between respondents. In discrimination cases, findings are often made against two or more respondents in respect of the same harm, typically against the fellow employee of the claimant who perpetrated the discriminatory act and the employer who's vicariously liable for that act by virtue of Section 109 of the Equality Act. In the case of the London Borough of Hackney and Sivananden, which you can see mentioned at the top of the slide, the EAT held that where there are concurrent discriminators, the usual award will simply be that each such respondent is jointly and severally liable. In such cases, the EAT, the then President, Mr. Justin Underhill presiding, held that the Employment Tribunal's discretion to apportion liability between the respondents exists only where the injury caused by the different acts of discrimination is divisible, in which cases, in a similar way to the apportioning of harm between discriminatory and non-discriminatory causes that we were talking about earlier, the tribunal can and should apportion to each discriminator responsibility for only that part of the damage which has been done by them. However, the EAT warned that split awards of that nature should only be made where such an order has expressly been sought by one of the parties, and if there is a proper legal basis for exercising the discretion to do that. The EAT also cautioned that a split award should not be used by employment tribunals to reflect their assessment of effectively who has the deepest pockets, which respondent is more likely to have the means to pay. Now, whilst Sivanandan clarified the law with regard to apportionment between respondents in general terms, a different question arose in the case of Brennan and Sunderland City Council, which is one of the leading equal pay multiple claims, which was whether there could be a determination by the Employment Tribunal of contribution under the Civil Liability Contribution Act of 1978, which allows one joint tortfeasor to recover a contribution from another joint tortfeasor based upon an assessment of what would represent a just and equitable contribution. Now, this is another decision of the then President, Mr. Justice Underhill. He held that neither the Civil Liability Contribution Act 1978 nor the Equality Act or any of the various antecedent discrimination legislation gave the tribunal jurisdiction to hear a claim for contribution. More significantly, he went on to give the view, albeit obiter, that the 1978 Act did not even apply to liability for discrimination in employment. He observed the legislature has simply failed to consider the question of contribution in the context of liability for unlawful discrimination. And since the right to contribution is a creature of statute, we cannot repair that omission. And he said that both the wording of the 1978 Act and the legislative history of that Act indicated that it was only intended to apply to liabilities which fell for determination in the High Court or the County Court, and that the Act created no right to contribution in relation to liabilities which had to be assessed by an employment tribunal. It's important to bear in mind, whilst not strictly speaking to do with employment, it has a bearing if you have to advise corporate clients in relation to discrimination in other contexts. Mr. Justice Underhill's analysis in Brennan doesn't affect the Court of Appeal's decision in the case of Ross and Ryanair Limited and another, which is a claim of disability discrimination in the provision of facilities and services, which remains authority for the proposition that the 1978 Act does apply to discrimination claims in respect of which the civil courts have jurisdiction, such as discrimination in the provision of services to the public. On a claim in that context, an employer could, if it chose to do so, seek a contribution from a jointly liable employee in respect of compensation it had paid out to a successful claimant. So, for example, if one of your employees racially abused a member of the public and you faced a discrimination claim on that basis, then the company could seek to recover against the individual employee. Over to Francis, who's going to go through some of the questions which arise in relation to divisibility.
Thank you, Anthony. That was I thought that was very helpful and interesting to hear what Underhill's obiter comments were at that point as well. But let's deal a bit more with the practical side of it for you. Now, questions on divisibility. Typical things that Anthony and I, when we butted our heads together, we thought, well, these are the sorts of things that we would want to see. And the first question to pose yourself is, well, why did the individual sustain that particular loss? And it sounds like a simple question, but there may be a multitude of reasons going to the cause why somebody has not got another job. And we're going to cover, well, we've covered that in some detail already. But the second point really is who is involved. So it's important to identify who are the putative discriminators in particular cases like this, because ultimately those are the individuals that you will, if you're acting for a respondent client, want to call at tribunal. Now, that doesn't take into account possibly tactical positions where so far as you get a witness and you think, oh dear, this is not going to go well, and you think that you can run the case based on documentary evidence alone. That's a separate matter. But it's important to identify who's involved throughout the various stages of the process and who can almost speak to the harm that's suffered by the claimant. Now, those types of cases will be quite rare because normally the only person and the tribunal will put stock in is the claimant as to what harm's actually been suffered. But it's an important thing to remember and think about in the wider remit of considering the case and prospects in general, not only on the liability section, obviously, but also on the remedy section. Now, how it's quantified, which is the third bullet point here, is also important. You've heard us talking about, and me talking about, schedules of losses running into the hundreds of thousands of pounds. A question for both claimant and respondent is, well, why? Well, why is the case valued at that amount? And Anthony very expertly took you through the Judicial College guidelines and the various factors in which an award may go into the severe category, moderately severe, and so on. If I'm acting for claimant, I want my claimant to address all of these matters, preferably in their statement, if not something very brief in the pleading. And by very brief, I mean very brief in the pleading, but that should really be explored as part of a witness statement. Particularly if if you don't have split liability and remedy, that needs to go in the single statement that's produced. And the same goes really for the respondent. If there's clear evidence that there is a minimal amount of harm caused by the potential act of discrimination that's relied upon. Clear example would be, well, claimant alleges that this terrible act of discrimination took place on the Friday. They came to work, were happy as Larry on the Monday. There were no issues raised by them, and that will also go into your other potential arguments that you may have to reduce compensation. For example, claimant doesn't raise a grievance. You may say they unreasonably failed to comply with the ACAS Code of Practice on disciplinary and grievance procedures. And that really runs into the next bullet point, which is, well, what's the practical consequences? What has actually happened as a result of the acts that have been complained about? Now, some of those may be very obvious, such as dismissal, but others may be a lot more nuanced. And it's important to identify what those practical consequences are. What are the steps that were taken on both sides in order to really try and build arguments on remedy? And that really, again, goes into, well, is it linked? The final point on the slide is something that Anthony's already alluded to, which is the issue of the medical report. So we've covered that. The long and short of it is that a claimant doesn't need an expert report to claim for psychiatric injury. However, it's preferable to get one. And specifically what the judgment says that Anthony was explaining to us earlier is what that says is that particularly when issues of divisibility and causative contribution are an issue, those are the circumstances in which it's preferable for the parties to get a report, and preferably a joint instruction is the best way to go with that. Now, trickier issues on causation, divisibility. Anthony and I have really covered the first two already here, which is intervening periods of loss, you'll recall, and mitigation, potential reasons for ongoing loss. You'll recall that Anthony helpfully took us through some case law on both the issue of when you have an employee who then goes and gets another job and then is dismissed from that job, and whether or not they can claim losses for that period. I think a fair assessment and, well, a fair summary of that, Anthony, would be to say if the intervening period, if the intervening job is of a short nature and it's reasonable for that employment to have ended, then liability for that subsequent loss could still be laid at the door of the employer.
Yes.
Now, a more interesting, a similarly interesting topic is the issue of shares. Now, what do we mean by shares? By shares, particularly, this is a issue as to whether or not someone can claim for a loss in valuation of shares in relation to their dismissal. And the typical issue here is, for example, there are a lot of employees and employers that run share schemes in which an employer will offer the employee some shares in their company. In response to that, there'll usually be a clause within the contract of employment that specifies that upon termination of employment, those shares need to be sold back to the company. And that's something that quite often people come across in contracts. Now, in the question really that arises here is, well, if I lose my ability for those shares, if I have to pay those shares back at a small rate, but then subsequently the company, for example, sells those shares onwards, or my shares would have been sold back at a higher rate in a couple of months' time, can I claim for that? Now, this issue actually came ahead in the case of Leonard and others and Strathclyde Buses. Now, this is a 1998 decision from the Court of Session. And in that case, the employees were forced, in the same way that I've been discussing, to sell their shares in Strathclyde Buses back to the company when they were dismissed. Shortly after this, Strathclyde Buses was taken over by another company, and they paid significantly more for the shares than Strathclyde Buses had done. So what the employees claimed as part of their compensation, they claimed for the enhanced value which they would have received for their shares but for their dismissals. And the first instance decision, the Employment Tribunal, they upheld that claim. Now that decision was then overturned on appeal by the EAT, but subsequently, on further appeal to the Court of Session, the tribunal's decision was restored, the Employment Tribunal's decision. And what the Court of Session did is they cautioned against introducing into the assessment of compensation for unfair dismissal principles of foreseeability or remoteness. And as you can gather, the EAT veered towards that. And what the tribunal said is that, at least in the Court of Session said that when you look at this, at least in the technical sense, those concepts apply in other legal contexts, tort, contract. But in this case, the increased value of the shares was a benefit that the employees would have enjoyed had they continued in employment to the date of the takeover. So this goes back to the point that Anthony made, in that the tribunal should assess, well, what's the period of loss? But what the Court of Session did is they said that the tribunal's decision to compensate the employees for the loss of share value was one that fell within the limits of a proper exercise of that discretion. And that goes again back to the issue about just and equitable circumstances. The next point is about a change of career. And change of career cases often hinge on the question of reasonableness. Is it reasonable for the claimant to have changed their career in the particular circumstances of the case? Now, there's no one-size-fits-all ideology here, and that is often the case with just and equitable cases. Each case is always assessed on its own facts. But a typical example here was Simrad Limited and Scott in the EAT. So an older case from 1997, but still worth reading if you've got this sort of issue. And in that case, what the EAT said is that the approach of a tribunal needs to consist of 3 stages. So firstly, tribunal has to quantify the losses claimed. Secondly, it has to consider the extent to which any or all of those losses are attributable to the action taken by the employer. And thirdly, the tribunal must consider whether in all the circumstances it's just and equitable to make the relevant award. So you can see how this still harks back to what we've been discussing. And it's that third stage is where the facts relating to mitigation will bear upon the question of the causative link. So it's essentially an equitable plea to be judged in the context of reasonableness. And that's ultimately what both sides should be arguing if you have a career change case. And again, from a pragmatic point, well, from a practical perspective, actually, look at that in terms of your witness statements and also in relation to your disclosure. Now, moving on to the final point on trickier issues, I'm going to invite Anthony to come back in because his PI experience will no doubt assist us greatly here. And we're going to briefly, Anthony, if you could explain to us the importance of looking at pre-existing conditions and situations when looking at these issues.
On a straightforward question of legal causation, you may very well be familiar, it exists both in criminal and civil jurisdictions, with the so-called eggshell skull principle, or in the context of psychiatric injury, what is called the eggshell personality principle. The description which makes no sense whatsoever, but you'll understand the meaning because it's an extrapolation of the eggshell skull, which is that you take your victim as you find them. But it's in this context that the distinction that I was talking about earlier between proving damage and the assessment of damages is important, because the more fruitful area for dispute from a respondent's perspective is not the initial causation argument, but rather the assessment stage. The argument for the respondent in cases of this nature is that irrespective of the discrimination that has been found against your client, some injury would have occurred in any event, because the eggshell personality claimant could have had a similar reaction to any number of other stressors. And as I've already mentioned, there are two key concepts when it comes to pre-existing conditions and pre-existing vulnerabilities, which are imported from the field of personal injury. Firstly, exacerbation. Secondly, acceleration. Now, exacerbation is where there is a pre-existing condition which the unlawful discrimination didn't actually cause, but it suggested that the unlawful discrimination made the symptoms associated with that pre-existing condition worse, either on a short-term or a long-term basis. And in those circumstances, the damage that you are concerned with isn't the totality of the damage. What you are concerned with is the damage which would not have occurred in any event. It obviously, as we've looked at before, requires there to be divisibility of harm, but there almost invariably will be divisibility of harm because you have a baseline to refer to in terms of the symptomatology from the pre-existing condition. The concept of acceleration is slightly different. Acceleration is where the relevant harm would, on the balance of probabilities, have occurred at some point in the future in any event. And the effect of the unlawful discrimination has been to bring forward the date upon which the harm has been suffered, either by a short or by a long period. And in a case of that nature, the appropriate assessment will be the loss during the period of that acceleration, because the argument, if you're acting for the respondent, goes any ongoing loss beyond that acceleration period would have occurred in any event. And in personal injury claims, it's common to adopt an exacerbation or acceleration approach to the assessment part of assessing damages. And as we've already seen, tribunals will have to as well, because tribunals have to approach the assessment of damages for psychiatric injury on the same basis as the civil courts, where acceleration and exacerbation are key concepts. And that's where expert evidence is particularly important. There will often be expert evidence about whether there was a pre-existing injury, which has been exacerbated rather than caused by the discrimination, or the chances of the claimant suffering a similar injury in the future. That's to say, acceleration. And it's important to stress that it doesn't require an excessively analytical approach, but certainly if you're acting for respondents, you should be asking medical experts to forecast, for example, the chances that a similar injury would have occurred at different times in the future.
Thank you, Anthony. With that, I'm mindful that we've gone over our slot. There are a lot of issues with these cases. They are complex in nature just by their very nature, talking about accelerated receipt, divisibility, untanglement of harm, and so on. So if you get in touch with our clerking team, if you have any questions on the seminar or comments, please do let us know and let the clerking team know. Be happy to pick up with you further from that. What I will do is quickly identify to you that I hope that you found this seminar.
You do have one specific question, Frank. I don't know whether you've seen it.
I think I have, and I think I've addressed it in the Q&A. Actually, let's have a quick look at it. Right, well, deal with this one. So the question is it common for the ET at the CMD stage to order the claimant to file a schedule of loss, but make no order for filing a counter schedule? Given the possibility the claimant may not stay the course or succeed at final hearing, do you have any view on tactics and if and when a counter schedule should be filed? Now, I've put an answer in the Q&A, but briefly, my view is this, and Anthony, do chip in if you have any other comment on it. I think it depends on if you're going to have split liability or remedy. If you're going to have split liability and remedy, then it's probably better to do a counter schedule once you get to remedy stage. If you've got if you've got joint liability and remedy, I think that a counter schedule of loss is worth it for a respondent, particularly if you can poke clear holes in what the claimant is claiming for. Now, for example, if their mathematics is clearly wrong on the schedule of loss, it can definitely help set the parameters, and that can be potentially agreed before a final hearing. As to injury to feeling, psychiatric damage, and so on, you can identify as well briefly what you say the award should be if the claimant does succeed, and just a couple of quick points as to why you say that. Generally speaking, I find counter schedules to be incredibly helpful, particularly if they mirror what the claimant is saying in their schedule of loss. So what you can even do is, depending on what the schedule of loss looks like, is have a separate column in which you identify what the respondent says compared to what the claimant says. That's quite helpful. It means that everybody then just works off a single document. I do find judges like to have that. It's a very, very good point, is that a judge will normally order a schedule of loss. If a counter schedule of loss is something that you are looking at because you want to run these sorts of arguments, then if it's raised by somebody at a case management preliminary hearing, then the judge may well say, well, either they'll make an order for it, or they may well say, well, I'm not going to tie you down to an order for it, but it's up to you if you want to put one in. And there's nothing stopping a respondent from preparing that. If anything, if it's done properly, the tribunal will be grateful for that assistance. So I'm all for a counter schedule of loss generally. The only negative, as far as I can see, is that you have some additional incurred costs on the part of the respondent early on. But then I do think that that's weighed up against there may be potential settlement that arises, because you then have a clear indicator of what the parties' positions are going into final hearing if the claim succeeds. Anthony, did you have anything else that you wanted to add on to that?
No, I agree with all of that. I think it also comes back to what we were talking about earlier, which is the point at which it becomes apparent that you are going to be able to, or it's going to be sensible to run apportionment arguments, because it may well be that that wasn't apparent at the time that you drafted your original grounds of resistance, because you had comparatively limited information in relation to what the claimant was claiming. You then see the claimant's schedule of loss. A counter schedule is precisely the opportunity to flag up potential apportionment issues and to make sure that they are on the tribunal's radar at a very early stage, and they're on the claimant's radar as well at a very early stage in terms of managing the claimant's expectations.
Absolutely. And I think that deals with the only other question that we had. I think there was one about as well, what were the books that we discussed. One of them is the Remedies Handbook, guidance for employment tribunals, and the other is the Judicial College Guidelines that Anthony mentioned, which is in its 17th edition now. The final slide that we've got for you is really advising you and informing you of the other seminars that are in this series, and you can see each of them there with the relevant dates. If you want to get in touch with our clerking team to get a link, there'll be webinars in the same way that this one was. We've gone a little bit over, as we've said, but these are all similar length seminars, all 1 hour or so, and you can see there's very helpful stuff in there in terms of the schedule of loss with Paul Wilson, Petar Starcevic, reconsideration with Bruce Frew, Connor Wright, and Felix Levi, and costs with Julie Duane and Tamsin Sandiford. So no doubt all will be excellent seminars. So I'd highly recommend that you get in touch with the clerking team and attend, because it's going to continue in the same vein. All of this is about dealing with remedy. And all of it is topics that I think sometimes get a little bit overlooked, certainly in my experience, wouldn't you say, Anthony, as well with
Yes,
yours?
absolutely. Yeah, absolutely.
Well, thank you very much for your attendance today. We hope that you found it useful, and our contact details are on the slide. The general email inbox is employmentandpi@stphillips.com. That takes you to the clerking team. So if there's any way that we can assist in the future, do let the clerking team know. And thank you very much for your attendance today.
Thank you.
Bye bye. Good morning.